As I mentioned previously, I haven't come prepared for this session. It's up to you to lead this. There was the suggestion from our last gathering that we work through the 2020 question paper today instead of during the workshop to allow you sufficient time to work through it. So I hope most of you have had the opportunity to work through the 2020 question paper. But before we kick off there, are there any questions that you would like to ask now that I can address in the meantime?
Hi, Marco.
Hi, who's speaking?
Christelle Masabata.
Hi, yes.
In terms of reading the case laws, are we supposed to cite them word for word, including the act, or we can just paraphrase what you remember, or everything has to be exactly the same wording?
In terms of the case law, as long as I can identify the case that you're referring to, so it's not necessary to give the full citation, but if you are referring to the Ensign Bickford case, that I just know that that is the case that you are referring to. So at least give me both parties, but I won't be too harsh in penalizing you for not correctly citing the case. When it comes to the act, as I said in the workshops, the wording is very specific in the act. So it is necessary to at least convey the correct meaning of a specific section or regulation when referring to that in the examination. Is that fine,
Okay.
Masabata?
Yeah, that's great.
Okay.
Thank you.
No problem. So the question paper has been set, it has gone through moderation and is sitting with the Patent Examination Board and with CIPL. The setup is very similar to the last two exams that I set in terms of there being a 200 mark allocation with a 4-hour examination time allowed to complete the question paper. The questions have been modified slightly, although there is a mixture of straight up theory. I've also included a bit more of an application type question or several application type based questions in the examination to try and test your knowledge of the Act and your understanding of the patent law a bit better and to see how you would apply it. But as I said, if you do work through the presentations and the recordings from our previous workshops, you should manage to do quite well in the exam. Please do read the questions very carefully, as there are several points and hints that you need to look out for in the question itself. So I would suggest that when you look at the question that you break it up into various components and to try and to see what it is exactly that I'm asking. So don't delve into it or go into a frenzy when reading the question. Try and break it up, digest it, and read it again before you answer some of the questions. Okay. Any further questions that you might have before we work through the 2020 exam paper?
Hi, Marco, Jackie.
Hi,
I just
Jackie.
check with you. So the last correspondence, if memory serves, indicated that there will be, if there's any changes, it will be communicated through to us around the exams. I haven't seen any, so I'm operating under the assumption that it's going to be online and it will take the form of an open book. Am I correct?
That's correct, but that is only for students that have registered with CIPL. So for the Patent Examination Board students, it will still be a closed book exam, as far as I'm aware. But for CIPL students, it will be online and it will be open book. And that's one of the reasons why I had to change the question slightly, so that it's not just a copy and paste from the Act for these CIPL students. You actually need to think about the questions and apply your mind to the question in answering them. Okay. Is that fine, Jackie?
Thank you so much.
Okay, no problem. Werner, you have a question for me.
Hi, Marco. Yeah, I'd just like to know with regards to the open, to it being open book,
Yes.
can we bring in any source, or is it only the Act, or are there limitations to what we can bring with?
I'm not too certain what SciPol has communicated to the students, to be honest with you. But as far as I know, it can be any of the source material.
Thank you so much.
Okay. Any other questions with regards to the exam? Okay. I hope you're all prepared and that the preparations have been going well. If there are no further questions, then I think we can work through the 2020 question exam paper together. Just by show of hands, did you have an opportunity to work through the paper? I hope so. Okay, great, thanks. Nicolette, you had a question for me.
Hi, Marco. How are you?
Yes.
I just wanted to check. So, you know, with these application type questions, and you mentioned that obviously it would be to test our understanding, read through it carefully, break up the points so we know what's being asked. And if these are like open-ended, open-ended type questions where maybe you can look at it in various ways, would you prefer a discussion on both angles? And then maybe leaning towards more of what we're going to conclude, and then obviously conclude with a definitive answer. Would that be fine, or
Yes,
would it be
that's
suitable to do?
perfect. Yeah,
Okay.
so obviously there has to be some reference to what the law states, or whether it's from the Act, regulations, or case law. If there is case law, what was found in the case law, applying it to those facts, and then drawing your conclusion from that. Look, in terms of the application type of questions in this exam, it's not too difficult, to be fair with you, because I also have to be careful when preparing these questions not to lead on to the Group 2 exams that the patent students write, because otherwise there's too much overlap between the Group 2 modules and the Group 1 module. So I still have to keep it within the bounds of a Group 1 module. So please don't fret too much about these application type-based questions. You'll see from the previous years, I did include some of these as well. I've just tried to steer more towards that direction, but it's really not too difficult. The exam paper itself is tricky, so you have to spend time in preparing for this exam in order to do well. Okay.
Thanks, Marco.
No problem. Yes, any further questions? I see you have your hand up. Liwalam, is that correct how I pronounce your name? Sorry.
The pronunciation is correct, but it's actually
Fantastic.
Nkosi.
Okay.
This is what happens when your device is used for homeschooling. I just realized now.
I thought I recognized this isn't the
I just
same
realized
person.
that I'm logged in under her name and not as myself. But anyway, Marco, I'm just concerned by this issue of those of us who are writing PEB are not writing an open book exam. And you've had to contend with the issue of striking a balance between questions that are not going to be just a pure regurgitation, but actually application. But does it not then disadvantage those of us who are writing PEB because we're not doing an open book?
No, it really shouldn't, and that's what I'm saying. If it's really not that detailed, the application type-based questions. So it's just painting a picture for you, and you being able to identify what the problem is, and then applying the law. So again, you're going to have to repeat the case law. It's not going to be drafting claims or amending a specification. It's not going to be anything hectic like that, or writing a letter of demand, something like that, you know, or any type of pleadings. So don't worry about that. It's still within the ambit of what is required for this module. So if you know the theory, you'll do fine. Honestly, I can guarantee it. Okay, so don't stress too much about that.
All right, thanks, Marco.
There's a good balance in this paper. There really, really is. Okay.
All right.
Yeah, I had fun setting it.
Will we have fun writing it?
I hope so. take some energy bars and snacks with you, and stay hydrated when you're writing. Yeah, and a blanket if you get cold. Okay, so if we then move on to the 2020 exam paper. So if we look at question 1, can you see my screen? Okay, perfect. So question 1, provide a brief summary of your understanding of the basic theory of the patent system and its purpose. So again, this was just a very open-ended question to help you settle into the paper. And this was basically your own words as to what you understood of the patent system and its actual functionality. So yeah, you would have to discuss the quid pro quo principle, you know, where for the disclosure, you are offered the rights to the patent for a limited period. And then what the purpose of the patent is, you know, it's to incentivize inventors or research and development, to drive innovation and technology, so on and so forth. So 5 easy marks there that could have been achieved for that question. If we look at question 1.2, you email a grant report to your client when you inform your client that the acceptance of the application has been published in the Patent Journal of 26 February 2020. Your client with a limited understanding of patent law asks you what is the effect of the patent proceeding to grant. Referring to the Act, explain to your client the type of right granted by a patent and advise your client on the effect thereof. So yeah, you can see that we've asked for the type of right. So as you know, it's a negative right because it's the right to exclude other persons from performing some of the acts. And as you'll see, I say refer to the Act, so you're expected to know which section to refer to, and that is section 45(1) in this case. And it's basically reciting what section 45(1) says, you know, where the effect of the patent is to grant to the patentee in South Africa the right to exclude others from making, using, importing, etc. So you're all very familiar with that as well. If we move to question 1.3, after providing your client with the advice relating above to 1.2, sorry, I see there are a few questions there. Stella?
Hi, Marco. Is my microphone working?
Yes, I can hear you.
Okay, perfect. I just want to know, is that all we have to say for question 1.2 for 9 marks?
Yeah, so the marks are allocated in terms of all the acts of infringement, because remember, section 45(1) states what the acts of infringement are as well. So the making, importing,
Yes.
so each of those marks would be awarded. But it also does mention what, again, the benefit of the patent is, and that's to allow the patentee the benefit to enjoy the profit accrues to him from the grant of the patent. Okay. Yeah, so to state that it was negative right was a mark, the section was a mark, and then referring to everything in 45(1) was also a mark.
Okay, thank you.
So 9 easy marks there. Masabata?
Okay, I think I had the same question. So the section 45 can be rightfully said that it's a negative right section.
That's correct, yes.
Okay, all right, thank you.
No problem. Okay, if we move on then, after providing your client with the advice relating to the question above in 1.2, your client informs you on 17 July 2020 that there is a possible infringement of the granted patent and that they immediately wish to proceed with infringement proceedings. Advise your client with reference to section 44(4) of the Act. Does anyone want to give this a go? Hi, Bianca.
Hi, Marco. Okay, I'll give us a go.
Yeah.
So, the application was only published on 26 February 2020, and then the alleged infringement took place on the 17th of July 2020.
That's right.
But then if you look at section 44, subsection 4, no, can you hear me? Sorry.
Yes, I can hear you.
Okay. No proceedings for infringement of a patent shall be instituted within a period of 9 months from the date of the sealing thereof, except where, written this somewhere, okay, except where you can get leave from the commissioner and you can show good cause that to institute such proceedings.
Yeah.
So that's what I have.
Yeah, so that's exactly what I was looking for. Yeah, so this was a bit of a trick question. If you didn't know that there's a 9-month moratorium, you probably would have been quite lost with this question, because you would have to look at the date of grant and when this client consults with you. So you can see there was only a 5-month period from the date of grant. So in terms of this section in the Act, there is a 9-month moratorium. But that moratorium can be lifted if you make application to the Commissioner of Patents and provided that good cause is shown as to why the moratorium should be lifted. If we look at subsection 4, in order to provide your client with an infringement opinion. Hi, Stella, I see you have a question again.
Sorry, Marco, just
No.
about 1.3 again. What would constitute as good cause shown in such a case?
To be honest with you, I'm not 100% sure. I mean, it's again one of those subjective things. So
Yeah.
it's where there is likely to be an immediate threat of irreparable harm to the patentee, for instance, or possibly a flight risk, you know, something
Yes,
like
okay.
that.
Okay.
I think if the courts had to look at it, they'd probably look at the same type of requirements for an interim interdict, perhaps, you know, which again
Okay,
is
yes.
irreparable harm, which
Yes.
the Beecham case dealt with that quite well. So if you do want to know more than that, you can have a look at that case. It's the
Okay,
Beecham.
I will do. Thanks, Marco.
Okay. Okay, so in order to provide your client with an infringement opinion, you are required to make a determination of infringement. Referring to case law, advise your client on the steps taken in ascertaining whether or not there has been infringement of your client's patent. Okay, so very easy. I mentioned this case earlier. That's the Ensign Bickford case. You just need to say that in terms of the Ensign Bickford case, there was a 3-step test by the court in determining the basis for an infringement. Masabata, your hand is raised.
Just to go back on 1.3,
Yes.
to answer that question, we just have to cite the section 44 for as is, or we
Yes,
also have to look at the date of grant, or
yes. So I mean, in most cases, it's always advisable to give your discussion. So say that there is a 9-month moratorium in terms of the Act. However, your client is consulting with you during that moratorium period, and then referring to the Act. Is that
okay,
fine?
makes sense. Yeah, thank you.
Okay, so 1.4 was just setting out what the 3-step infringement test was in terms of the Ensign Bickford case. So there you first have to determine, was the act alleged actually an act in terms of the Act, or can it be excusable? Then you would have to construe the claims. So in that case, you would break up the claims, as I mentioned, into your integers and compare it with the alleged infringing article, and then decide whether there is a valid defense. Okay, so in advising your client on this, that's the test that you will look to. 1.5, very easily, to what relief is your client as the plaintiff in proceedings for infringement entitled? So that is the interdict, delivery up, damages, in lieu of damages, a reasonable royalty, And then also, as I mentioned, don't forget to pray for costs. Okay, so there's nothing out of the ordinary from question 1, as you can see. Perhaps the moratorium did throw some students off that were unfamiliar with that. Question 2. So this question relates to questions 2, 3, and 4, the synopsis that's presented to you. So you consult with your clients, a software engineer, Mr. Robot, and a medical doctor, Dr. Jekyll, who have collaborated on the development on an invention that they now wish to protect. Their invention is for mobile application that is able to integrate with the databases of doctors and dentists in order for a patient to complete a new patient questionnaire and to facilitate the booking of an appointment. So I'm sure you all have seen some system like this if you visit a doctor before. But if we look at question 2.1 then, given that this is the first dealing with your clients have had in seeking patent protection for invention, advise your clients with reference to the acts on the extrinsic requirements or the legal standards that an invention must meet in order to be patentable. So that delves right into section 25(1) of the Act, where an invention must be novel, it must be inventive, and it must have utility. So it must be capable of being applied in trade or industry or agriculture. So a very straightforward question that. Furthermore, advise your clients on the exclusions from patentability in terms of section 25(2). You're all very familiar with this already. That is anything which consists of a discovery, a scientific theory, mathematical method, etc., is excluded from patentability. So you're all quite familiar with that as well. 2.3. You as an expert in intellectual property law advise your client that copyright protection automatically comes into existence when the screen layout and computer code of the mobile application is reduced to material form, provided that it is original. However, copyright protection only extends to the unauthorized copying of the screen layout and source code without affording any protection for the reproduction of the functionality of the mobile application. Advise your client with reference to the Act on the patentability of their mobile application. Is there anybody that wants to give this one a go? Okay, let's give Stella a chance.
Hi, Marco. I think you answered this question in your Protect Your App article.
That's exactly where this came from.
Which
even the wording comes from there.
yeah. I think although section 25(2) excludes a computer program from being patentable, I think 25(3) states that or in light of section 25(3), you can patent the functionality of an app, like how it interacts with hardware, for example. Or
okay. Yeah, so you're on the right track there, Stella. Let's hear what Nicolette says as well before we go into it further.
So yeah, I was also going to say, based on your article, the 25 subsection 2 does exclude computer programs. But if you're looking at the functionality of the app, the same thing that Stella said, and then I said, so we are looking at it offering a technical solution to a problem. If it can do that, then it's it might be patentable. And I also made a note here that it would have to meet the section 25(1) requirements that we discussed, because clearly the copyright doesn't really prevent others, and you mentioned in your article, from mimicking or reverse engineering the functionality. Yeah.
Okay, yeah, so you're both on the right track there and correct, in fact. So yes, in terms of section 25(2), the computer program itself isn't patentable, but section 25(3) basically says that section 25(2) should be given a broad interpretation. So it mustn't be interpreted too narrowly. And that, if you look at 25(3) specifically, it says that the provisions of subsection 2 shall prevent only to the extent to which a patent or an application for a patent relates to that thing as such, anything from being treated as an invention for the purposes of this act. So you're right, where there is some technical effect, you are likely to obtain patent protection for it. And that's the same provisions apply to all of the exclusions in section 25(3). Okay, so all on the right track there. Thanks. If we move on then to 2.4, it transpires during your consultation that Dr. Jekyll briefly discussed the idea of the invention with a colleague whilst attending a seminar in Switzerland. Advise your clients in detail with reference to section 25(5) and 25(6) of the Act, as well as case law, whether or not the patent may still be patentable in South Africa. Okay, so 25(5) deals with what is novelty. It says an invention shall be deemed to be new if it does not form part of the state of the art immediately before the priority date of the invention. So you would need to discuss the definition of novelty. Then you would have to discuss what is the prior art. So section 25(6) says that the state of the art or prior art shall comprise all matter which has been made available to the public in the Republic or anywhere in the world by any way. Then if we look at the case law, that was the Macaulay Corporation case, and then just a discussion as to what the Macaulay Corporation judgment held, and just your brief discussion on concluding on those facts and the application of the law to that. Okay, so quite an easy question there. Bless you, Kimberly. Okay, any questions so far? Okay, so that one was for 8 marks. Quite a big question, that. Dr. Jekyll, during your consultation, also informs you that he has developed a refined method of surgically removing a patient's appendix. Dr. Jekyll asks if he may obtain a patent for the method he has developed. Referring to the Act, advise Dr. Jekyll on the patentability of his method. Okay, anybody want to give this a go? No? Any takers? Okay, Nicolette.
Well, I'll try.
Thanks.
Does it relate to the section 25(11)?
Yes.
Where the method of treatment is not patentable.
That's exactly it. So it was just a discussion on section 25(11), saying that the method of treatment on the human or animal body is not patentable. Okay. We move to 2.6 then, referring to case law, advise your clients how the Court of the Commission of Patents assesses the novelty and inventiveness of an invention. Okay, before we go on, Asila Funo, you have your hand raised.
Hi, Mako.
Hi,
On that one, how are you?
well, in you.
I'm good, thanks. On the previous question, does it also depending where you are? Because I think it was mentioned that in USA you might find that the method of treatment is patentable.
Okay, yeah, so in this case, we're dealing with South Africa. It doesn't explicitly state that, but remember, it's your client that you're consulting with. So it would be for South Africa, yeah. Okay, so 2.6 basically wanted the discussion on the test for novelty and inventiveness. So the test for novelty was the Genti-Rucco case. And that just said that the claims of the patent have to be construed, the prior art has to be construed, and then you have to have a comparison between the claims and the prior art to assess whether the invention is novel or not. And for novelty, you're not allowed to mosaic prior art documents, if you remember correctly. The disclosure has to be in one single piece of prior art in order for it to be novelty destroying. Then the test for inventiveness was the Ensign Bickford case versus AECI explosives. And again, that just set out how the courts would need to assess inventiveness. So you can have a look at that. And remember, for inventiveness, you are able to take from all the prior arts in determining whether an invention is inventive or not. If we move on then to 2.7, it comes to light after conducting a patentability search that there has indeed been a prior disclosure of your client's invention. Briefly explain to your clients the provisions of the Act dealing with the exceptions regarding novelty, where there has been a disclosure of the invention, but the novelty thereof is not destroyed. So you may recall from the presentation that we worked through during the workshop that there were a few slides that touched specifically on this, and it was set out quite nicely. So what we were looking for here was the second medical use. So where there is a disclosure, but that disclosure doesn't necessarily render the invention not novel. Okay, so you would have to discuss section 25(9) of the Act that deals with second medical use. Then the second exception would be section 26, where there is prior knowledge or publication of the invention, but that it is excusable in terms of section 26. And that is where somebody discloses the knowledge without your consent or acquires the knowledge without your consent. And then the steps that need to be taken in order to secure your rights, and that is that you must apply for a patent with all reasonable diligence as soon as you become aware of the unauthorized disclosure. And then also further in section 26, in section 26(2), if the invention is being worked in South Africa by way of a reasonable technical trial by the applicant or patentee. So remember that the technical trial must be within the borders of South Africa. Okay, if we move along then to question 3.1, he proceeded to file a provisional patent application for Mr. Robot and Dr. Jekyll 5 months ago for their invention. However, they have since made an improvement to the invention and now wish to file a provisional patent application that will include subject matter of the first filed provisional patent application, as well as the improved subject matter. Your client informs you that they do not intend on claiming priority from the first filed provisional patent application when they filed local and foreign patent applications. They will instead only claim priority from the second filed provisional patent application. So this one is quite a mouthful, and this is one of those questions we actually have to digest it and read through it more than once to understand what it is that we're looking for. But in your own words, discuss with reference to section 31 of the Act, which is the section that deals with the claiming of priority. What is essential for you to do in order to properly claim priority from the provisional patent application that you'll file during the course of the upcoming week. So this is a situation where your client has already filed a provisional application, but they have made improvements to their invention and they're filing a second provisional application, but they don't want to claim priority from the first filed application. So what must they do in order to ensure that no rights are lost? Okay, so yeah, you would have to look at section 31(2) specifically. In this case, where the applicant would either have to withdraw the application, so they would have to file a formal request to the patent office to formally withdraw the first filed provisional application. Okay, so that the document remains a secret document and that there's never any disclosure of the first filed provisional application. Okay, so it either has to have been abandoned, withdrawn, or refused without being open to public inspection. So very important that provisional must never have been made available to the public. Otherwise, there will be a disclosure of the invention. Also, there must be no priority rights claimed from that first filed provisional application. So you won't be able to withdraw the first filed priority application or provisional application if you have filed a complete anywhere in the world where you claim priority from that application. And then you need to ensure that there are no rights outstanding in the convention country in question that relates to that previous application. Okay. So this again touches on the Benz case as well, although that wasn't what I was specifically looking for, yeah, but just so that you are aware of the Benz type situation that we come across a lot in practice is where an applicant claims priority from an application which isn't the first filed application. Because remember, you have to claim priority from the first filed application for an invention in order to have a valid claim to priority. Okay, so what you would have to do, yeah, is you would have to formally abandon the first filed application, and then you can proceed to file the second provisional application. Okay, and also just important to remember the Form P3, where there is a declaration on the Form P3 that states that the priority claim that's stated on the P3 is the first application in respect of that invention. So if you haven't formally withdrawn the application and you filed the second priority application and you're claiming only that second priority application, you would be making a false declaration and your patent, once granted, will be open to revocation. Kimberly, you have a question?
Hi, Marco. Sorry, I was just wondering again what no rights are outstanding means.
Let me come back to you on that one. I will digest it and get back to you. Okay. Okay, if we move on to question 3.2 then. Your clients have proceeded to file a complete patent application claiming priority from the newly filed provisional patent application. Again, a few months down the line, your clients contact you to inform you that they have made an improvement in the invention described in their complete specification. In terms of the provisions of Section 39 of the Act, advise your clients fully on what option exists to them to protect their improvement to the invention already disclosed. Give your client a concise summary of the contents of Section 39. So as you can see, this is clear regurgitation of Section 39, and it deals with the provision of a patent of addition where there has been an improvement to an invention where you can then file a patent of addition. So this is just reciting what we know in terms of Section 39 of the Act. So I'm not going to go through all of that again. You can have a look at that yourself. Stella, you have a question?
When answering this question, Marco, do you want us to like basically set out the whole of Section 39? So Section 39.
Well, I mean, it doesn't need to be word for word, but the main points have to be there. So when can you file for a patent of addition, for example? So a patent of addition can be applied for before grant or after grant, okay? And in terms of what can you apply for a patent of addition, so it has to be some improvement to the disclosure or addition to the disclosure. Okay, and then, you know, all the aspects that relate to renewals and assignment. Can you assign the patent of addition separately or not? So it doesn't have to be word for word, but in your own words,
Okay.
out each of those points is very important.
Okay, thank you.
No problem. Okay, if we look at question 4 then, your client provides you with an instruction to file a complete patent application for their invention in South Africa in the names of both Mr. Robot and Dr. Jekyll. So you can see this is a case where we have joint applicants. Referring to section 29 of the Act, describe the rights and restrictions placed on co-applicants of patent applications and the remedies in the event of any dispute. Okay, so the rights and restrictions, that is neither of the co-applicants can deal with a patent application in any way without the consent of the other. So they're not able to license or assign the patent application without the consent of the other. The only exception to that limitation on co-patentees is in the event that they need to save the application. So one may instruct the payment of renewal fees without the other, or to ensure that the application is never abandoned or goes into a lapse. Then dealing with any disputes, the disputes must be addressed to the Commissioner of Patents, who will hear the matter, and then just touching on those provisions in terms of the Act as to who will be liable to costs and what remedies exist. So in most cases, the Commissioner will ensure that the rights to the application are preserved and that there is the eventual grant of a patent, and in some cases ensure that the one applicant assigns his rights to the invention and to the application to the other party. Okay. So again, quite a straightforward question there. Question 5.1. Your foreign instructing attorney contacts you on behalf of their client, whom you represent in South Africa. The client has patent applications across multiple jurisdictions for the same invention. The instructing attorney advises that the client wishes to amend the South African patent specification so as to limit the scope of the claims to distinguish the invention more fully over prior art. The prior art was cited during examination in Europe for a corresponding European application. The South African application is still pending and is due to be accepted shortly. Advise the instructing attorney who is unfamiliar with South African patent law on the requirements for such an amendment by referring to the relevant section of the Act and regulations. So that whole initial blurb of who's instructing you, that's pretty much all just irrelevant. It's just setting the scene for this question. So, you know, this might sound like a mouthful and be unfamiliar to a lot of you. So, as I said, this was just basically to set the scene. What is important here is to note that the South African application is still pending. And remember, in terms of the Act, there are 4 instances where an application or a patent can be amended. So that's a provisional application can be amended, an amendment before grant, an amendment after grant, and also then the amendment during litigation proceedings. Okay, so in this case, this is a complete that we're dealing with, and it hasn't been accepted yet. So it's still a pending application. So yeah, you would need to discuss the requirements in terms of an amendment. And importantly, it says with reference to the Act and regulations. So what I was looking for here was that in the application for an amendment, you have to set out the nature of the amendments. So in the specification, you have to indicate what it is that you're amending. And that's what we mentioned previously is commonly referred to as your reds and your clean copies of the specification. So basically your track changes to indicate what it is that you're deleting, what you're inserting in your amendments. And then also importantly is to provide the full reasons for your amendment. So those two requirements have to be met in terms of section 51.1. Then in terms of section 51.6, the amendment can't introduce any new matter. So you're not allowed to add subject matter that wasn't previously disclosed. And then the amendment also needs to be fairly based. Okay, so the most important thing here was to make that distinguish or to be able to distinguish between the type of amendments and then what the requirements are in terms of the Act and regulations. Everyone happy with that? Okay. Would the requirements be any different if the acceptance of the application had already been published in the patent journal? Okay, so that's a clear indication that the patent is now granted. So is there any difference in terms of the requirements? In this case, yes, there is a difference in that the amendment must be wholly within the scope of the claims included in the specification before amendment. So you can't take from the specification that the disclosure in the specification has to be contained wholly within the claim of the scope, the scope of the claims, sorry. Okay, so that's the third requirement. Some people also mentioned that for a post-grant amendment, you also need to publish the amendment in the patent journal. So you would have been awarded marks for either of those answers that you provided. Okay. Sorry, but that actually reads on to 5.3, which was the what additional step needs to be taken in terms of an amendment made after grant, and that is the publication in the patent journal. If we move on to 5.4, your client also informs you that they have received a unity of invention objection in the European examination report and asks for your advice. Draft a response to your client setting out what the Act states in terms of section 62 regarding a patent comprising more than one invention. Also advise your client on what action may be taken irrespective of the provision of section 62. Discuss the provisions of the Act and refer to relevant case law. Okay, does anyone want to give that a bash? No answers. Hi, Stella.
Hi, Marco. I'll try the first part,
Yeah.
which is that I think it's section 62 that says that a patent should only be granted for one invention only, but that it's not a ground for revocation if there's more than one invention.
Okay. Yeah, so that's exactly correct. So you would have to state that although there is a unity of invention objection, and the Act does state that it shall be granted for one invention only, there's no remedy should somebody wish to revoke the patent on that ground. So what can you do in that instance, even though there is this provision in the Act? There is another provision in the Act that allows for this to be remedied.
You can file a divisional application.
Yeah, so that's exactly correct. So in terms of section 37, the option does exist to file a divisional application. So that's what you would have to discuss in a bit more detail then, is that the option is available to file a divisional patent application where you split the inventions into separate applications. And yeah, you'll see that I did ask that you refer to case law. So that was the Bayer case that said that the claims must not be identical. So they must be coterminous with each other, although there is some overlap that is allowed. Also importantly, you need to remember when can you file a divisional patent application. So a divisional patent application you can only file before the parent application is accepted. Okay. And then you would also antedate the application to the filing date of the parent, so that you still have that valid claim of priority. And then also that the first filed application won't be novelty destroying against the divisional application. Okay. Yes,
Can I just ask, what's your view on filing a divisional of a divisional? Is that something that is possible?
So I know that's very debatable amongst the practitioners and the various firms. Some firms are of the view that it's not possible to file a divisional on a divisional. This is just to give context to everyone that's listening in, whereas other firms feel that you can. My personal view is that you are able to file a divisional from a divisional. And the reason why I say that is because if you look at the wording of the Act, section 37(1), it says that a fresh application is made. So even though it's a divisional application, it is a completely new application that has its own life, that runs its own prosecution and runs its own course. So my view is that it is possible to file a further divisional application from a divisional application. Some people have the opposing view and say that you can only file from the parent.
Okay, thanks, Marco.
I don't know. What's your view?
I agree with you, I think, because in my mind, a fresh application is like a new application.
Yeah.
And it has a life of its own. So in my mind, you can file a further one.
I think so too. The problem with that is that people will file divisionals and divisionals and divisionals. I know I've had a case where we've filed, I think, 11 divisional applications before, which is
from one parent application.
From one application, yeah.
Oh wow, okay.
Hi, Bianca.
Hi, Marco. Sorry, I just have to confirm the case law here.
That was Pharma Dynamics versus Bayer.
Okay, thank you.
Pleasure. Okay, 6.1. South Africa, as is the rest of the world, is faced with a crisis in the wake of the COVID-19 pandemic. So this was just when the shit hit the fan, so to speak. Sorry, excuse my French. The world's hope in combating SARS-CoV-2 is in the successful development of a vaccine. Or at least now we have the vaccine, everybody. Well, it's there. We might not have it, yeah, but it's somewhere. Government's still procuring. Fast forwarding to the future, a successful vaccine has been developed, trialed, patented, and placed on the market. Okay, so you can see those questions completely relevant today. As we know, in terms of Section 4 of the Act, the state is bound by a patent. In terms of Section 4 and Section 78, what remedies does the state have in order to gain access to the vaccine for the people of South Africa? When may the state do so, and what requirement or requirements must be met? So Bianca, your hand is still raised. Is that from the divisional question? Do you have a further question?
Yes, that was from the previous question.
Okay, that's fine. Okay, so let me just find my notes, sorry. And you'll see this again relates to the article that I sent to you all again recently. So yes, the state is bound by the patent, so they also cannot just walk in and take over somebody's patent. But the Minister of State may use the invention for public purposes on such terms as agreed upon. So there has to be an agreement between the minister and the patentee on the use of the actual patent. Or it can go to court and the commissioner can decide on what conditions the state may use the patent. Okay, but both parties have to be heard in that instance. Okay, the minister may also acquire the rights to the patent, again, as such terms and conditions may be agreed upon. So the one deals more with the use of the of the patented invention, whereas the other is the actual acquisition. So basically the same as the acquisition of land, expropriation of land. There is a provision in terms of the Patents Act for the state to acquire the rights in the patent and to expropriate it. But there must be an agreement between the parties. Okay, so that is quite a straightforward question there. Apart from the state, any interested party may also seek to obtain a compulsory license to the invention subject of the patent when there is an abuse of rights. So referring to the Act, what conditions are deemed to indicate an abuse of rights of a patent? So this one again is quite straightforward. You all know, you should all know this by now. That is where the invention isn't being worked in the Republic to an adequate extent. The demand isn't being met in South Africa. The patentees being unreasonable in granting a license, and it is prejudicial to the public, or it is in the public interest that a patent should be licensed. If the demand is being met, but it's being met by importation into South Africa, and then also that the price charged is excessive. So quite a lot of points to refer to there in question 6.2. Yeah, but all quite straightforward. But you can see how well you need to know the Act. Hi, Makosi.
What is the exact provision for question 6.2?
Section 56.
Thank you.
Okay, question 7. Your client advised you at the time of filing their patent application that you are not responsible for the payment of renewal fees, and that the responsibility of the payment of renewal fees will be handled by a global renewal agency. However, your client contacts you in a state of panic 5 years later after the application proceeded to grant and informs you that their patent has lapsed due to the non-payment of renewal fees. The patent is extremely valuable to your client who still wishes to make use of their monopoly over the invention. Referring to the Act and regulations, advise your client on what can be done, what requirements must be satisfied, and what procedure must be followed. Okay, so what the client can do is they can apply for the restoration of the patent for the lapsing of the patent that was then either unintentional, or it must have been unintentional, the omission to pay the renewal fee, and that there was no undue delay in bringing the application to the registrar. So remember, the restoration application is made to the registrar of patents. It's not the commissioner that will assess the restoration application. And the application must be made in the form that mirrors a notice of motion, and it is obviously like an ex parte application. Okay, so again, quite straightforward there. I think you should all have a good grasp of this by now. Is there an opposition period to oppose such an application? So yes, there is. It's a 2-month opposition period in order to oppose. So remember, the registrar will advertise that there has been an application for restoration in the patent journal. And from that date of publication, any member or any person can oppose the restoration of the application. Hi, Stella.
Mark, I just want to know that 2 months, how is it calculated? Is it 2 months like
So
from the date of publication?
Yeah, so it's 2 months from the date of publication.
Okay, so it wouldn't be like in 2 patent journal publication months time.
No, it's 2 calendar months. Yeah.
Okay, thank you.
Okay, referencing the Act, advise your client on his limited rights should he be successful in his application. So that is looking at section 48. Okay, and that is where somebody has commenced using the invention during that period where it is lapsed. What can the patentee do? So he can't institute infringement proceedings, etc., etc. So you can all just have a look at section 48.1 there for that. I'm not going to go into all that detail now. Stella, you have another question?
No, sorry, I just forgot to put my hand
Okay.
down.
Okay, question 8, the famous revocation question. This one has probably been asked in every question paper to date. And that is that the Act provides for an exhaustive list of grounds on which a patent may be revoked, lists these grounds. So you can all do this at section 61. And that's discussing what those grounds of revocation are. So the person was not entitled to the invention. The requirements in terms of section 25 haven't been complied with. There's inutility, insufficiency. The declarations that are lodged contain a false declaration that the patentee should have known or ought to have known. So again, I'm not going to go into detail on this one. It's all in section 61. Okay, and as you'll see in this question, where there is reference to another section in the Act, it asks you to just briefly discuss that. So just touch on that then, as or should a question like this arise again. Okay. Any questions so far? Yeah, no. Okay, question 9.1. Your client contacts you and informs you that he has verbally assigned his valuable patent to a reliable friend of his. Advise your client whether there has been a valid assignment of his patent and what steps should be taken for the assignment to be effective against third parties. Also, by when should this step be taken? Are there any takers? Yeah. Somebody want to give this one a bash? No. Okay, so the Act mentions that for there to be a valid patent assignment, the assignment must be in writing. So in this case, there's been a verbal assignment, so it's not valid. So you'd have to mention that the patent assignment must be in writing. And in order for it to be effective against third parties, you have to record the assignment at the South African Patent Office in the patent register. And that has to be done within 6 months of the effective date of the assignment. Okay, it is possible to do it after the 6-month period, but if you do so, then you have to request condonation from the registrar for the late recordal of that assignment after the 6-month period within which to record the assignment. Okay, if we move on to 9.2, what conditions in a contract of employment shall be deemed null and void? So any condition, a contract that requires an employee. Hi, Bianca.
Hi, sorry, I just wanted to give it a go, but you. Sorry.
Oh, sorry. Okay. You can carry on.
Okay. Well, basically, I said section 59, subsection 2 is where it requires employee to assign to his employer an invention made by him otherwise than within the course and scope of his employment, or restricts the rights of an employee in an invention made by him more than 1 year after the termination of a contract of employment shall be null and void.
Okay, yeah, so that's perfect. So any invention that an employee has devised that is outside of their scope of employment cannot be assigned in terms of the employment contract to the employer. And also, you cannot then claim the rights to any invention devised by an employer or an ex-employer, employee, after 1 year of the termination of employment. So anything that they've devised after 1 year is not the employer's entitlement. Okay, if we move on to question 10, with the aid of Annexure 1, which is a copy of the Patent Register of South African Patent number 2019, Answer the questions that follow by providing the dates in full where relevant. Okay, so if we look, oh, sorry, it's probably quite difficult for you to see this. There we go. That might be better. So 10.1 asks what was the last day of filing a PCT application? Okay, so remember, in terms of the Paris Convention, a complete application or a PCT application must be filed within 12 months from the earliest priority date. So you'd have to go and look at this register page to establish what is the priority date, which is over here. So the priority claimed is from this European application, and the date here is 29 September 2016. So the last day to file the PCT application would be 12 months from this date, which would therefore be 29 September 2017. Okay, 10.2. What was the last day for filing a national phase patent application in South Africa without an extension? Who wants to give that one a bash? Hi, Stella.
Hi, Marco. It's you have a 31-month deadline. I haven't calculated what that is.
Okay.
But yeah.
31-month deadline, but from where?
From the earliest priority date.
Yes, that's correct. So you would have to calculate 31 months from the earliest priority date within which to enter the national phase. So the last day then would be 29 April 2019. We move to 10.3. What was the last day for filing a national phase patent application in South Africa with an extension? So as you know, there is an extension provided for late entry into the national phase in South Africa. Who knows how many months that extension is? Nicolette?
I think it's up to 34 months, so maybe by the 29th of July 2019.
Yes. Yep, that's perfect. So there is a 3-month extension, so the absolute deadline is 34 months. But you need to make an application to request that late entry when you file your application. But the ultimate deadline is then 29 July 2019. Okay, when was the first renewal fee due without an extension? Who wants to give it a go? There was no tricks in terms of renewals in this case. Anyone? Hi, Sipokazi.
Yes, it's 3 years from the lodging date. So it would be the 6th of September 2037. No, sorry, 2020. 6th of September 2020.
Yeah, okay. Just importantly, sorry, this is this is still from my draft of the exam of 2020, so this date here is incorrect. But for a national phase patent application, it's 3 years from the international filing date. So when a question like this does arise in the exam, you need to identify whether it's a national phase patent application or whether it is a straightforward convention application. So in this case, it's a national phase patent application because you'll see there's a reference to the PCT application number here. So then you know your renewals are calculated from the international filing date. So you're absolutely correct in that case. Okay. Okay, and then What is the last day on which the first renewal fee must be paid with an extension? So remember, there is a 6-month extension period allowed as well. So the answer there would be 6 December 2020. If all renewal fees are paid, when will the patent expire? So how many years is a patent monopoly for?
10 years.
How many?
10.
No,
Oh,
20.
20.
20 years.
Okay,
I
so
thought now, I just thought of design, functional and aesthetic, sorry.
that's fine. Okay, so don't confuse those that are writing designs. Aesthetic design 15, functional design 10, patents 20. Okay. So yeah, 20 years for patents. And that again, for a national phase patent, will be calculated from the international filing date. Okay. Guys, don't change the 6 to a 5 in your answer. Literally add 20 to the year. Okay. So just the tip there, it'll be 2037, 6 September. So 6 September 2037. So it doesn't expire on 5 September. I got that a lot in the exam, okay? It's 6 September 2037. Sipokazi, another question?
Yes, Marco, can I take you back to question 10.5? Is the 6-month calculated from the first initial renewal date? Because you said December 2020.
September.
10.5.
Sorry, it's March.
2021, right?
Sorry, as I said, I'm using my drafts from last year. It wasn't the final stuff. Okay. Yeah. Sorry about that. So just to correct everyone, 10.5, the answer was 6 March 2021.
Marco, and what was that the date for 10.4?
10.4. Let me just double check this here. Sorry, this is so it would be 6 September 2020. Yeah. Okay, then the last question for the 2020 paper. If the priority claimed was from a South African provisional patent application, so they're saying that instead of this EP application, it's actually a South African application, but with the same filing date that we're claiming priority from. And your client decided not to file a PCT application, but to only continue with the South African complete application, claiming priority from the South African provisional application. What would have been the last day for filing such a complete patent application? Hi, Nicolette.
I think here they would have up till 15 months. So the general rule is 12 months plus a 3-month extension. Yeah,
so that's perfect. So remember, if it's a South African provisional application and you're claiming and you're filing a complete application in South Africa that claims priority from that South African provisional application, you have 12 months within which to file, but there is a 3-month extension permissible. So again, that 3-month extension you need to make on request, but the absolute deadline then within which to file the complete patent application would be 15 months. So the answer there would be 29 December 2017. Great, and that brings us to the end of the 2020 exam paper. So do you all feel a bit more confident now? They're not too tricky, but you do need to know the act quite well. Hi, Bianca.
Hi, Marco. I'd just like to ask you, if you compare this paper or the 2020 paper with the one that you've said now, what if you compare them with one another, is the 2021 the paper we're writing now maybe a bit more difficult or on the same level as the 2020 paper?
I've got it, yeah.
Oh.
Give you a tease. No, it would be on the same level. In
Okay.
fact, it's the types of questions are quite similar to 2020's papers as well. Okay, but you do definitely need to know the act quite well. Okay.
Then,
Obviously a few tricks here and there that you need to be able to spot in order to push you up to distinction. Okay, so it's just to distinguish between those who pass and those who get distinctions.
okay, and then I'd just like to know, with this HR1, it's like questions based on this is a nice type of, you know, way of asking it, but except now, besides giving or providing us with a register page, how can such a question also be asked, like a timeline, or is mostly a register page that can be given, or if I ask this now?
Yeah, so it will either be a register page, or instead of it being in this table format of the register, it will say the filing date of the PCT application was 6 September 2020. So it would just be in a paragraph manner.
Okay.
And then you'd have to extract it from that information. Okay. Any further questions?
Oh, I'd just like to thank you.
It's a pleasure. Okay.
No.
Nothing else? Hi.
No further questions, Marco. Just to thank you. I think you've been really, really helpful beyond just lecturing us. You've also given us some useful practitioner tips. So the rest is up to us, I suppose.
Thank you.
Thank you very, very much. Be kind in your marking, Marco.
Thank you.
Thanks, Marco.
Thank you, everyone. Just before we close off, sorry, let me just mute everyone again. Yeah, just before we finish off, I do wish you all well again in preparing for the exam. If you haven't already started, it might be a bit late because you've got less than 2 weeks before writing this paper. But to those of you that have and who still need to, I wish you all the best in preparing for the exam. I'm sure it will go well. Please don't get too panicked when you sit for the exam. As I said, digest the questions, read them through carefully before delving into it. You've got more than enough time. 4 hours is ample time to take your time in answering the questions. So with that, I wish you all well. If you do have any further questions, please do feel free to contact me. And I'll be happy to take your questions. Kimberly, I will get back to you on your question as well. I have made a note of it, yeah, and I might just respond to everyone on that one, but I'll need to go and think about it. Okay, so thanks, guys. Have a wonderful afternoon, hopefully with electricity. Okay, take care. All the best.
Thanks, Marco.
Pleasure. Bye-bye.
Bye.
Thank you and bye.
Thank you. Bye-bye.